Hey all, welcome back to the Law Read Slowly. In the last session, we were discussing the consequences of you filing your suit in a court that lacks jurisdiction. We have discussed the importance of jurisdiction. We have understood the meaning of jurisdiction. We have understood the differentiation between jurisdiction and competency. We did a proper case on it. Then, when we started discussing what happens when you file your suit in a court that lacks jurisdiction, the first consequence we discussed was return of plaint. We've also written about it, we've discussed it in detail. It is dealt with under Order 7, Rules 10, 10A, 10B, read with Order 43, Rule 1, Clause A. We have also written about it. And return of plaint, can happen at any stage of the suit. It can happen either before the summons have been sent to the defendant. It can happen either after the summons have been sent to the defendant, when the defendant is in the court, while the judgment has not yet been pronounced. After the judgment has been pronounced, that is when your case is in appeal. Even then, return of plaint can be resorted to if the appellate court feels that the case was not to be heard by the trial court because it did not have jurisdiction to hear the case. Before we proceed, let's read Rule 10. Return of plaint. Subject to the provisions of Rule 10A. Why? We already know, because Rule 10A is what is saying that in certain situations, instead of returning the plaint, the court can fix a new date of hearing for the parties in the court where the case should have been filed. And who will tell the court? Which court is that? The parties will tell the court that this is the court where I will file this plaint after you return it. So I pray that this honorable court may fix a date for us in that court already and notify the parties about such fixation. Subject to the provisions of Rule 10A, the plaint shall at any stage of the suit be returned. It can be returned at any stage of the suit, be it before judgment, after judgment, before defendant has come, after defendant has come, after arguments, before arguments, during the arguments, to be returned to be presented to the court in which the suit should have been instituted. So it's the whole thing is about jurisdiction. The main issue is jurisdiction, because the court which is returning is not the court where it should have been instituted. It means that the court in question lacks jurisdiction. Explanation: for the removal of doubts, it is hereby declared that a court of appeal or revision may direct, after setting aside the decree passed in a suit, the return of the plaint under this sub-rule. The return of plaint can happen at appellate stage or revisional stage as well. Then we have Rule 10A. We have already read and discussed it. Then we have also understood that when a return of plaint is done, an order will be passed by the court, where the court will lay down what? That it is returning the plaint. This is the reason why the plaint is being returned. An endorsement is also done on the plaint itself, that this is the date the plaint was presented. This is the date when the plaint is being rejected. This is the person who presented it. These are the reasons for the return of plaint. All of that will be endorsed. Once you get return of plaint order, you are also free to do what? You are free to challenge that order itself by way of appeal. It's provided for under Order 43, which is the order dealing with appeal from orders. Appeal from decree is in Order 41. Appeal from orders is in Order 43, read with Section 104. We've already read this, so I'm just making references to it. So you can either go in appeal from that order where the court has said that this plaint should be returned for lack of jurisdiction in this court. You go in appeal, the appellate court will hear your appeal against that order. Appellate court might say that yes, this court does have jurisdiction and the order to return the plaint was not correct. Then the court will send the case back to the trial court to be tried properly and proceeded with. But if the appellate court says that it agrees with the order of the lower court, that is, that the lower court lacks jurisdiction to hear this case, then the appellate court will tell the plaintiff, the original plaintiff, that take this plaint back, it's being returned, and file it in the court where it should have been filed. Now, at this stage, what can the plaintiff do? He can request the appellate court also that this honorable court may please maybe please fix a date in the new court where this case should actually be tried, and notify both the parties about such fixation of the date in the new court, so that the parties can then appear on the fixed date in that new court and get their case heard. And once such fixation is done by the court in another court, now the new court, it need not serve new summons, because we've discussed the whole point of serving summons is to inform the parties that they are supposed to show up in the court on so and so date for so and so business. But when the previous court, which is fixing the date for them, has already notified them of the date which it has fixed and the court in which it has been fixed, then there's no point for sending summons. But still, if the new court feels that there is some reason in justice which requires such summons to be sent once again despite the original notice, it can send the summons also. So that is what return of plaint is. Now, apart from return of plaint, there are two more things that can be done when you have filed your case in a court lacking jurisdiction. There is a concept of withdrawal of suit. You have concept of institution of suit, which we have been discussing over the past sessions. So you have a right to institute a suit under civil law. You have a right to file a case. But you can also withdraw a case that you have filed. But withdrawal does not come as easily under law as does the institution. You can't just play out your whims and fancies in the legal system, because that will just lead to wastage of everybody's time. You feel you want to file this case today, tomorrow you feel that you don't want to continue with this case, so you just want to withdraw it. How do you withdraw it? Do you just wake up one fine day and stop going to the hearings and just withdraw, abandon it? No. Abandon and withdraw are actually two different terms, and both have meaning in law. Because you can abandon a suit, that is, you can give up, that I don't want to pursue this any further, I am abandoning it. Or you can withdraw, as the meaning of simple English meaning of these words suggest. Abandonment is where you abandon something. Withdraw is where you take it back because you want to do something about it. Maybe you want to file it in another court. That's giving you the hint into what we can do. You want to file it in another court, or you know it's going to fail. There's some mistake in the plaint that you have made and you want to correct it. So you are withdrawing the case for now and you will correct those mistakes and then come back. So that's withdrawal, and this is amendment. In our case, we are concerned with withdrawal. So what you can do is, you can seek permission of the court. You can inform the court, you have to justify your withdrawal, that okay, there is a case that's ongoing, I want to withdraw that case. The court will ask you why, because you just cannot withdraw a case in a routine manner. There may be more than one plaintiffs. One of them wants to withdraw, others don't want to withdraw. Can that one force everybody and just withdraw the case? No. He has to notify every other plaintiff. He has to explain and justify to the court that why has he, after so long spent on the case, now wants to withdraw the case. He has to give court a reason. Once the reason is given, once the reason has been justified, then the court will allow for the withdrawal of this suit. And while it is being withdrawn, you are withdrawing it, fine. Maybe you made some mistake, but you are the one who made that mistake. Just because you made a mistake, you weren't vigilant enough, we are allowing you to withdraw it. But now, should we again allow you to file it once again? Will you automatically just come file it again after correcting the mistake and then again ask that court to spend time on that? No, not as a matter of right. What you will have to do is, when you are withdrawing a suit in this manner, because there is some technical mistake, then you will also have to seek permission of the court while withdrawing itself, that I am withdrawing this suit, but along with an order to withdraw, I am also seeking the permission to refile it after correcting whatever mistake is leading me to withdraw it in the first place. Court will do a hearing on that, seeking of permission. And then, when satisfied, for the reasons of justice, the court will allow for such permission. So you will always withdraw your case with the leave of a court, the permission of the court to refile it. Because if you don't take that permission to refile and you just seek a withdrawal and you withdraw it, you cannot refile it. Then you're stuck with it. Just take it back home then. You can't refile it. That's why This permission to file it again along with seeking withdrawal becomes very important. Now, what can generally be the reasons for such withdrawal? It's usually when there's a technical mistake. For example, limitation is barred, so you're continuing with it. Nobody in the case has figured it out. The defendant has not raised an objection to it. Case is ongoing. Court has also not somehow noted that. But you know, as a plaintiff, that if it's a suit barred by limitation, I'm wasting time on it, I'm wasting money on it, I'm paying lawyers' fees, I'm paying for printing of paper, I'm paying for coming to the court, I'm paying for staying at the hotel during hearings. So instead of spending all that money, you feel that I might as well just withdraw this case. So you yourself can apply for withdrawal. Jurisdiction, our main point, is also a technical shortcoming of a case. If the court lacks jurisdiction, at the very outset, the court is not allowed to hear that case. We have seen a semblance of how jurisdiction is something that you have to check at the very outset, because we saw Order 14 Rule 2, where general rule is that every court will have to decide upon all the issues that are framed in a suit. But sometimes, if one or two of these issues are such that they're preliminary in nature, that is, that they relate to jurisdiction, then the court is allowed to not follow the general rule of deciding upon every issue. Rather, the court can first decide upon the jurisdiction issue, and if the court lacks jurisdiction, then court can avoid deciding on all the other issues, because anyways its decision on all the other issues will not hold any value because it does not have jurisdiction in the first place. That's why jurisdiction becomes very important. If the court does not have jurisdiction, there's no point going anywhere. So even if your case has already been going on, plaintiff's evidence has happened, defendant's evidence has happened, arguments have happened, we are waiting for the judgment. Even at this stage, if the court does not have jurisdiction, that judgment will be useless, because that court could not have heard it. Just because the court has spent so much time, it will not lead to the fact that, oh, okay, we have wasted so much resources on this, people have spent so much time, parties have spent so much time, so we might as well make an exception, and despite the lack of jurisdiction, let's allow this judgment to hold value and for this judgment to be binding. No, jurisdiction is very important. It goes to the root of validity, it goes to the root of competence of a court. So if the court lacks jurisdiction to hear that suit, even if discovered by the plaintiff himself at a later stage in the suit, then such plaintiff can request the court to allow it to withdraw the suit along with the permission to refile it. Because if it doesn't take the permission to refile it, then while he can withdraw it, he'll be stuck with it. He cannot refile that suit again. Clear? So this is the second recourse. First was return of plaint. Second is this, that when you filed your case in a court lacking jurisdiction, but here the opposite party has not realized that the court lacks jurisdiction, you also didn't realize court lacks jurisdiction, court also didn't take note of it, then you yourself can apply at a later stage whenever you discover that, oh my god, that there is no jurisdiction with this court to try this suit. Then you can yourself apply for withdrawal of the suit, along with it seek the permission to refile it after withdrawing. That is what you can do. Now, there are many aspects to it which we will discuss when we discuss the provision related to abandonment and withdrawal. But for our purposes right now, in the jurisdiction topic, this is what is valid. This is what is relevant for us. Now let's read the provision. We have understood the full extent of whatever is required for the purposes of jurisdiction in this topic. Now you'll read the provision, it will be amply clear to you. What we will read now is Order 23, Rule 1, Sub-Rule 3. Because Order 23 is about both abandonment of a suit and withdrawal of a suit. We are not concerned with abandonment right now. We are concerned with withdrawal. And Rule 1 is dealing with both abandonment and withdrawal. So withdrawal is talked about in Sub-Rule 3 of Rule 1. Let's read it.